Today we had come for the mention of the cases that were not heard by the judiciary concerning the, the purported impeachment of His Excellency Gachagua and the purported ascendancy to the Deputy President's position of Honorable Abraham Kithure Kindiki. Now, our petition was not heard due to the deliberate sabotage by the judiciary to purport that on the 4th of June, when the case was supposed to be heard, that the case was due for mention. The judges have said today that there was supposed to be communication to me, which they didn't verify, and that I should have been notified that the case would not take up for hearing on that day, and that would come for mention today. Wonder of wonders, I tell the judges that, look, you've already rendered yourselves in the main petition, E565 of 2024, in which you have said that the impeachment was purportedly correct and in line with the constitution and the law of the Senate, and yet you have fined the Senate 50 million shillings for that supposed impeachment. In our petition, we say that there was no impeachment in the first place. And we have said that according to Article 145.1 and Article 145.2, the threshold required to impeach a president and a deputy president is that all the members of the National Assembly have to be present, either voting yes or no to that impeachment. You cannot have 291 members and saying you have a full house. The adjective used is all. Unless they understand and perceive the adjective in the English language all to be different, our petition raised that issue. They chose and elected not to hear us. They chose and elected to determine that petition, raising that ground on the threshold and alleging that it was constitutional. Unless they're not reading that part of the constitutional right, which we invited them to do, and they rejected, and now they have pushed us to the 29th of September. After they have decided on it, it can only be said that the judiciary is running away and escaping from its constitutional mandate and duty and responsibility. Wonder of wonders, in that judgment, after it was rendered, or before it was rendered, just at the moment of commencement, their lordships and her leadership told the Kenyan people, and indeed the entire world, this judgment we're about to read is going to be long. You better see it in for the long haul. It's 350 pages. 350 pages. Ladies and gentlemen, that came from the tulips. And they commenced reading until 8 p.m. But somehow, by a twang of circumstance, they have a 286-page judgment. So I tell them, wait. When you told us it was 250 pages, and we listened to you with the contradictions therein, today we have a judgment that is 286 pages, and they say, you know, some of us have glasses. You know, some of us read in different fonts. You can't blame us if we were reading with large fonts. And finally now we have small fonts. Kenyan people have to wonder, what sort of a judiciary does tell you that we have a judgment ready for 350 pages? But after the fact, after the hullabaloo and the noise that the Kenyan people say that, wait, what sort of a judgment have you rendered? They give us a 286 pages. What did they slice off? An excision in terms of 64 pages from that judgment. What is it that they are afraid the Kenyan people are going to see in that judgment? Did they skip reading those 64 pages? Or have they doctored now their final judgment? But the judges told us, you don't need to question us about 350 pages that we told you of, and now you have 286 pages. We are living in a country that does not give any precedence to the principle of transparency, honesty, and integrity. And so I told their lordships and her leadership, please recuse yourselves. Get off hearing this case because you no longer can be fair and cannot be objective. You've already rendered your judgment.
which you say shifted mysteriously, somehow mutated from a 350 page to a 286. And they say that, well, we will not recuse ourselves. We will hear you on the September 29th and 30th. And we're going to hear you online. They will hear this petition online. And then it says that his petition was never heard. Our petition was never heard. And then they tell us, do joint submissions. Joint submissions. From whence do you get those sort of directions? Then they say that you will be heard online. We cannot hear you in open court. I don't know what they're afraid of. That we will come to open court just like everybody else who was heard in open court. And that will be heard online. Now, you know the online system, that the systems fail. In the first place, this petition was blocked through that online system. Now, Article 50, sub-Article 2D of the Constitution says that every person has a right to be heard in a court of law constituted under the Constitution, in public, open court. Now, your electronic gadget is not a court. Being in an office or a bedroom is not a court. This is a structure the taxpayer is paying to maintain on a daily basis. Close the courthouse, railroad everybody online and tell them that use your gadget. Let's go through a colonizer's platform called Zoom or any other platform. Forget about your structure here that you're paying and you've designated as a courthouse. Ladies and gentlemen, this is what we have in terms of rendering of judgment. My question to them was, now that you've already rendered your judgment in the Gachagua so-called impeachment, and I've shown you that they could never have met this threshold, are you going to depart from your judgment that you've already seen? How intellectually honest is that? There is intellectual dishonesty, apart from judicial mischief and dishonesty. Well, but they say, we will hear you online. Now, you can predict that those are not people who are minded to give you fairness or justice at all. Now, if our judiciary is serving some other political interest and not justice, and that we are paying tax money for that, then we better close the courthouses. And we be told that it is a decision that is made prior to you coming to court. Don't even bother coming to court because it is a predetermined decision. That's the impression. That's the impression.
Sorry. That's okay.